Hello everyone, Mr. Lipchick here, and our discussion is going to be about national and state powers for this segment of instruction. Division of powers. Federalism is an evolving concept and has changed since the founding of the Constitution. The Constitution divides powers by giving certain specific powers to the national government and reserving all others for the states and the people. Some powers are shared by the state and national governments. Some powers are denied to all levels of government. National powers. There are delegated powers, powers that the Constitution grants or delegates to the national government. There are three types of delegated powers: expressed, implied, and inherent. Expressed or enumerated powers are directly stated in the Constitution by the founders. These include the power to tax, declare war, raise an army and navy, and regulate commerce between states. Implied powers, while not specifically stated in the Constitution, are said to spring forth from the stated powers. The elastic clause, the necessary and proper clause in the Constitution, allows Congress to create any law that is needed in order for it to exercise its powers. And there are inherent powers, and these are powers that the national government has by virtue of simply being a government, such as the power to control diplomatic relations, immigration, etc. State versus national power. Reserved powers are powers the Constitution reserves strictly to the states. These are not specifically listed in the Constitution. The Constitution states these powers as those powers not delegated to the United States by the Constitution, nor prohibited by it to the states. In other words, if the national government does not have a specific power according to the Constitution, and if the Constitution does not prohibit the states from having this power, then it belongs to the states. And a good example would be public K-12 education. The supremacy of national power. Article 6, Section 2 of the Constitution is known as the Supremacy Clause. The laws of the United States shall be the supreme law of the land. No state law or constitution may conflict with any form of national law. All state officials and judges are bound to support the Constitution. A good example would be in 1957, Governor of Arkansas refused to desegregate the public schools as required by law, and President Eisenhower sent federal troops in the form of the 101st Airborne to Little Rock to make the state comply. Because local governments derive their powers from the states, they are also bound by the Supremacy Clause. There are concurrent powers. Concurrent powers are powers held by both the state and national governments. Each level of government, state and national, exercises these powers independently. Examples include the power to tax, create courts, make laws, and enforce laws. Denied powers. Article 1, Section 9 of the Constitution enumerates things that the national government cannot do. Examples: cannot tax exports, cannot interfere with a state's ability to carry out its responsibilities. Article 1, Section 10 prohibits states from exercising certain powers. Examples: they cannot make treaties with foreign governments, cannot grant titles of nobility, The purpose of denied powers is to preserve the individual rights and liberties of the citizen. National guarantees to the states. Article 4, Sections 3 and 4 outline 3 obligations of the national government to the states. 1. The national government must guarantee each state a republican form of government, that is, a representative democracy. When Congress allows senators and representatives to be seated in Congress, it is confirming to the states that they have a republican form of government. After the Civil War, Congress denied seats to senators and representatives from the southern states until they agreed to ratify the Civil War amendments guaranteeing the rights of former slaves. Two, another guarantee, protection of the states from invasion or domestic violence. When there is rioting or civil disorder, the president can send troops to a state in order to restore order. The 1967 Detroit riots are an example. When federal rights are being violated or ignored, the president can send troops to that state to enforce them. The desegregation of Little Rock High School in 1957, as we previously discussed, are an example. This guarantee has also been extended to send troops and supplies to states experiencing national disasters. 3. The national government has a duty to respect the territorial integrity of each state. It cannot take territory from a state to create a new state unless the legislature from that state gives the national government permission. The admission of West Virginia in 1863 was an exception to this rule. The Civil War was taking place, and the counties making up West Virginia, then a part of Virginia, did not want to leave the Union. Congress held that the representatives from this area were the only legitimate active body in Virginia at the time, and therefore admitted West Virginia to the Union. West Virginia did not share the slaveholding economic and social system of Virginia. The admission of new states. The Constitution gives Congress the power to admit new states to the Union. There are 2 restrictions to this power. 1. No state may be formed by taking territory from another state without its consent. And 2. An act of admission by Congress is subject to presidential veto. Procedure for the admission of new states. 1. Congress passes an enabling act, allowing the people of a territory to seek statehood to create a constitution. So if they're looking for statehood, they will have to first write a constitution. 2. The constitution that is created is submitted to a popular vote within the territory. And 3, if the Constitution passes the vote, Congress is still in favor, it passes an act admitting the territory as a state. Congress may impose certain conditions before admitting a new state to the Union. Once the state is admitted, however, those conditions can only be enforced if they do not interfere with the new state's authority to manage its internal affairs. The Supreme Court has ruled in favor of the states in these matters. The decision was based on a constitutional provision that all states are considered equal in their privileges and obligations. National Governors Association. Founded in 1908, the National Governors Association has grown in power. It is not an official government body. The governors of all states meet and discuss solutions to problems experienced by the states. They also lobby the national government for changes that are helpful to their states. Obligations of the states. States perform 2 important functions for the national government. 1, they conduct and pay for elections of all national government officials. They fix the times, places, and manner of the election of representatives and senators. And 2, the states have a deciding role in whether or not to amend the Constitution. Amendments must be approved by 3/4 of the states in order to pass. The role of the federal courts in federalism. The federal courts act as an umpire in settling disputes regarding federal and state powers. The Supreme Court case of McCulloch v. Maryland in 1819 ruled that in cases of national versus state government, the national government is supreme. Basically what happened was Maryland government tried to tax a federal bank located on its state territory. This ruling began a tradition of the Supreme Court ruling on cases where there are disputes between states and national governments. The outcome of such cases has varied over the years, depending on the justices serving on the courts. That concludes our discussion of national and state powers. Thank you for your viewing, and I look forward to seeing you in the live lessons. Have a great day.